Regulations versus best practice, what school professionals need to know. I'm Marie Ireland with the Virginia Department of Education.
And I am Shannon Hall Mills with Florida State University.
This presentation was selected by peer review and originally presented at the November 2012 ASHA National Convention by members of the SEA-CDC. This general overview is provided to assist professionals across the nation. Please contact your state education agency for specific information or questions. State education agencies, or SEAs. State education agencies promulgate state regulations. They interpret federal regulations, manage and distribute funds. They adjudicate complaints and resolve disputes within the state. They monitor the local education agencies, LEAs, for compliance. They provide technical assistance to LEAs. They also publish guidance and best practice documents. These responsibilities are outlined in the Code of Federal Regulations. Have you ever heard someone say, "But ASHA said we should use workload, not caseload"? Or, "That's not how we did it in my last school"? Or how about, "I heard that SLPs in another state don't have to do things that way"? This is because there are regulatory differences. Things like the maximum caseload permitted in the state may vary. What about the criteria for eligibility for speech-language impairment? States may have regulatory differences in the maximum group size for Medicaid billable treatment sessions, and also differences in what to do if parents do not give consent for an IEP change. As professionals, we must be aware of differences and follow our own state and local requirements to remain in compliance. Have you ever heard the saying, "When you've seen one state, you've seen one state"? It's important to be sure that we're following the law and the rules. Laws and rules may be set at the federal, state, or local level. A statute is a term describing something that must be followed and can be changed following a legislative process. Regulations or rules must also be followed, but they can be changed following a strict administrative process. Jurisdiction is defined as the official power to make legal decisions and judgments, or the extent of the power. It's important to know who has jurisdiction anytime you're asking a question about professional practice. Federal and state statutes and regulations and rules. Statutes are passed by the government. Rules and regulations may be promulgated by the federal or state agency, such as the Department of Education at the federal level or your state education agency, Department of Instruction or Department of Education. Changes to state law or regulation must follow an approved process. Interpretive authority. Once a law or regulation is written, governments have interpretive authority when those regulations are open for interpretation. For example, when the law says significant discrepancy, each state may interpret the definition of significant discrepancy. If the state does not define significant discrepancy, then local education agencies have interpretive authority to help define that for their staff. Interpretations cannot conflict with law or regulation, and those interpretations may be written as regulations, which must be followed, procedures, which should be followed, or guidance to help staff understand best practice. An example of interpretive authority. In the Code of Federal Regulations, the definition of speech-language impairment means a communication disorder such as stuttering, impaired articulation, a language impairment, or voice impairment that adversely affects the child's educational performance. The interpretive authority allows that states and LEAs may provide guidance or establish specific criteria. You'll see a list of a number of states that have specific state interpretations that define language impairment. The criteria in Ohio, Colorado, Florida, and Virginia define what has to be met in order for a student to be eligible. Do you have specific criteria in your state? Another example of interpretive authority is that caseloads for speech-language pathologists are not addressed in federal regulation. Some states may limit caseloads for speech-language pathologists in regulation, and others may not. Some examples on the right side of your screen are caseload limits that are set at the state level. Ohio's limit is 80, Virginia's limit is 68, South Carolina's limit was 60, and Oklahoma determines caseload based on IEP services, while Florida, Colorado, Wisconsin, and Utah are examples of states who have decided not to exercise their interpretive authority, but allow local interpretive authority or local control. And you can see that one county may have a caseload greater than 100, where another may have a caseload around 45. There are some other types of rules to follow. Policies are written to explain the process as long as they do not conflict with regulations of a higher entity. So federal, state, and local regulations must agree. They must be followed to remain in compliance. Procedures are written to explain the process, and again, they are not permitted to conflict with regulations of a higher entity. But it is not a compliance violation if you don't follow a procedure. There may be a disciplinary action, but that is a local decision or a state decision based on the way the procedure is written. An example of local policy or procedure could be something such as records retention, specific special education forms or software used at the local level, procedures for updating staff on rule and regulation changes. Medicaid billing procedures may be set at the local level, and also student assistance or intervention team procedures. Best practice and professional guidance. Best practice and guidance documents can be issued by local education agencies, state education agencies, the American Speech-Language Hearing Association or state speech-language hearing associations, university programs, or any group or author. These best practice and professional guidance documents do not replace regulations, policy, or procedures. They may be consulted to answer complaints or issues. They may be used to advocate for change, but they are not binding, although they do carry weight and guide professionals in their practice.
Some groups of school-based speech-language pathologists have identified some common areas of concern. One of those areas involves general speech-language pathology best practices. Another area incorporates components of evaluation, eligibility for services as a student with a speech-language impairment, and related services in speech-language for students with disabilities. Other areas of concern include looking at specific disorder categories and treatments for specific communication disorders, licensure and or certification rules laws and policies for speech-language pathologists. Also, how are speech-language pathology assistants licensed, certified, and utilized in the school setting, including how are they supervised and how is the supervision provided. Another area of concern voiced by school-based SLPs includes Medicaid, including the provision of Medicaid-eligible services, documentation of services provided, and reimbursement procedures. Another category of area of concern for school-based SLPs includes the provision of interventions for children who are not yet identified as children with disabilities under IDEA. This includes services that are provided by speech-language pathologists as part of a problem-solving team, as part of an intervention assistance team, within the multi-tiered system of supports, or MTSS model, including their involvement in response to instruction or response to intervention, RTI activities. To find some relevant guidance and resource links, we encourage you to visit the website for the State Education Agency's Council for Communication Disorders. This provides specific guidance links from multiple states. Some of the examples of the resources available on the website are listed here. Some of the resources include, from the state of Virginia, a guideline package for speech-language pathology services in schools, including best practice guidance. For North Carolina, there is a manual of guidelines for speech-language pathology services in schools. Virginia also offers a document that focuses on evidence-based practices specifically. Wisconsin offers a document providing guidance on speech-language impaired assessment and eligibility criteria. In Florida, there are documents including technical assistance regarding the role of the speech-language pathologist in supporting reading growth among students. And of course, outside of the states, the American Speech-Language Hearing Association, or ASHA, also provides guidance in terms of roles and responsibilities for school-based speech-language pathologists. This is an example of the webpage for our council. It shows you where you can access state web pages that are specific to the area of speech-language impairment, provides some programmatic and related service resources there. Also, there are links to state guidance documents that provide general speech-language pathology guidance and technical assistance. And you can also link to your state-level speech-language pathology consultant through our contacts on the website. We provide updates to that website as new resources become available from the states who participate in the council. Now we're going to speak for a moment about what happens when the rules and the guidance may provide some conflicts. One example of a conflict is the issue of the term caseload versus workload. When we talk about the amount of work that school-based speech-language pathologists do in a typical school year, there are many conversations and discussions that revolve around the caseload, what type of cases make up a school-based speech-language pathology caseload, as well as what is an overall workload approach as recommended by the American Speech-Language Hearing Association that incorporates not just the number of children served through an IEP in the area of speech and language, but what are the other activities the SLP is engaged in to support those services. For example, activities done on behalf of students, as well as activities done face-to-face with students. Another example of where some conflict may arise is in discussions about the SLP's role in providing services in a response to intervention or multi-tiered system of supports model. Each state at this moment is determining what the allowable level of participation is for a school-based speech-language pathologist. As a professional organization, the American Speech-Language Hearing Association supports the SLP's involvement in different areas within RTI and MTSS models. Well, what this looks like for the individual school level SLP will vary based on state, school district, and even school level recommendations and policies. So at times we know that best practices may appear to conflict with regulatory or procedural requirements. What is a professional to do when this happens? As a bottom line, professionals must follow all current regulations and policies to remain in compliance. Even if there are some conflicts between new emerging best practice, we have to allow time for those regulations and policies to be updated per the best practice. So in the meantime, professionals can investigate those issues. They also should be engaged in advocacy for change at their state or local level using the latest and greatest best practice information. We also know that conflicts can occur because of misinterpretation or miscommunications about information. For example, we know that sometimes information is either misinterpreted or miscommunicated because of perceived or real barriers to implementing something new. We also know sometimes that local requirements can surpass or conflict with state requirements. An example of this is when guidance is provided at the local level that's using cut scores or specific tests that have to be used. Sometimes the local school district may require this of speech-language pathologists. Sometimes that guidance is then interpreted as a rule or a law, and it indeed may be simply guidance that's misinterpreted. So these are opportunities for the professionals to seek clarification between guidance and regulation, and also to advocate again for updated guidance that reflects best practices. Also, we know that sometimes states may be required to implement new regulations due to findings from federal oversight. One example in the recent years is within the state of Florida, the state education agency, the Florida Department of Education, was required to provide guidance to school districts about the provision of speech-language therapy as a related service. That provision of guidance on related services came as the result of a finding due to an Office of Civil Rights complaint that speech and language as a related service was not being provided to students with disabilities in the state of Florida. So there was some time required between the state education agency developing, sharing, and disseminating some new technical assistance on that topic. And that took time between the state education agency and the local education agencies. So one thing for professionals to consider is the time that it takes for that information to be shared to the school level SLP. Also, stakeholders and advocacy groups may have differing viewpoints on possible changes that are in draft form, changes that are coming about in laws or regulations. An example from the state of Virginia is that they now require parent consent for any changes made to that IEP. This is more conservative than the federal requirement through IDEA for notifying parents of changes to IEPs. Parents view this as a right, and local education agencies may be required to implement something that's not required at the LEA's expense. We also know that sometimes conflicts may occur because professional practice changes can happen quickly. This is particularly the case when we talk about evidence-based practices in education and evidence-based practices in speech-language pathology. For example, we know that there is recent research on the sensitivity and specificity levels of norm reference tests, and particularly looking at a large group of norm reference tests for language. There are authors, including the Betts et al. Study from a year ago and Spalding et al., that show very few of these tests are appropriate levels of sensitivity and specificity for accurate identification of language impairment among school-age children. Many states have guidance or regulations that refer to a specific test score for eligibility determination. Such setting of specific test scores seems to be in direct conflict with these findings from research. We provide the references for you here so that you may also refer to these references. We also know that conflicts can occur because laws and regulation changes do take time and resources. One example that's affected all of the states was the timing of the reauthorization of IDEA. It was officially reauthorized in December of 2004, with the rules and regulations for how to carry out the reauthorized IDEA being available 2 years later in 2006. State regulations must follow state process, which may extend the timelines. For example, in Virginia, the regulations were adopted in 2010. Consider your work setting and the context of your own state. Is there a conflict that comes to mind that you believe should be addressed in your state? Here we're going to provide 2 examples of state-level initiatives that have resulted in positive gains for practice and resolved a conflict between regulations and best practice. The 3-to-1 service delivery model has been a nationwide advocacy initiative to use more of a workload approach in the schools for school-based speech-language pathologists. The way the 3-1 service delivery model works is that therapists provide 3 weeks in a month of direct services. That includes IEP services for direct therapy provision. And the 4th week, or 1 week of the month, is in focusing on the indirect service provision, all the other components of the workload, things that are done on behalf of the students served. In the state of Wisconsin, the speech-language pathologists wanted to pursue the option of the 3-1 service delivery model. However, at the state level, it was not permissible for IEPs to reflect a service delivery frequency per month in terms of minutes of therapy per month. So the State Education Agency and a group of stakeholders met to discuss the options. How could they document services on IEPs that was compliant with federal and state regulations, but also allowed flexibility so that service delivery options could be considered for individual IEPs that are meant to reflect the needs of individual students. As a result, this group drafted and the State Education Agency approved wording to allow minutes per month as a service delivery option on IEPs in the state of Wisconsin. And so as a result, the option for providing a 3-1 service delivery model was supported and allowable in the state. Other service delivery models were allowable as well, but it was considered a good initiative in Wisconsin to align some current best practice with the allowable flexibility with how time is determined for an IEP. Another example of a successful state-level initiative was any time that a state has to revise the criteria for students to become eligible as students with a speech or language impairment, the states go through a process to update their regulations. In previous versions of Florida and Virginia's regulations at the state level, their regulations did not address children with dialectal or cultural linguistic diversity. And so some students may have been determined eligible as students with a speech or language impairment, even if the primary characteristic was due to a dialectal feature or cultural linguistic diversity. So as a result of gathering stakeholder input and working with the state education agencies, the current language in both of these states now reflects the fact that teams need to consider dialectal, cultural, linguistic diversity factors in determining eligibility for speech-language services. In other words, those should not be the primary factors for what would explain a language impairment or speech impairment. And so language was added to the regulations following state process for comment by the public and final approval to ensure that students will not be found disabled primarily because of social cultural dialects or other linguistic concerns such as limited English proficiency. So in terms of advocacy, school level and district level and state level speech-language pathologists have a role in pursuing advocacy initiatives in their state and their location. When advocating for change, there are some important parameters to consider for any professional. First, identify the issue. This seems like a straightforward point, but sometimes identifying the actual issue underneath the discussions can be a challenge. So it's good to work with a group of stakeholders to identify the issue at hand. Also identify who has jurisdiction. Think back to the beginning of this presentation where we talked about different levels of jurisdiction. So once you've identified the issue, who has jurisdiction to address the item in question? Is it at the federal level, the state level, or the local level? If it's at your local level, is it within your local school district, or is it down to the school level? Also determine if compliance is required. So before any changes are made in regulations, policies, procedures, and whatnot, compliance is still expected of the professional for the current language, for the regulations that are in place at the moment. So make sure that compliance is maintained and see whether it's an issue of interpreting compliance. Also determine and propose a timeline for possible changes. Identify stakeholders for collaboration. Keep in mind that you should have stakeholders from your professional association, your state education agency, perhaps any other regulatory agencies in your state, such as the Department of Health. Also consider stakeholders at the local level, school districts, as well as school level key personnel, and also consider if you're looking at some changes to advocate related to best practice, you may also want to incorporate stakeholders from university programs in speech-language pathology. A group of stakeholders can then draft information and gather supporting evidence and work towards a combined collective change with a common vision. Some advocacy resources for professionals to consider and places or documents to gather that might help support your advocacy work include state-level rules and regulations, state-level technical assistance documents, also perhaps any state-level guidance or best practice documents that are provided to ESE personnel, general education personnel, and anything specific to speech-language pathologists as well. Also gather documents that support and explain differing legal opinions on your topic, and also look at your professional association, for example, the American Speech-Language Hearing Association, or even some of the state-level speech-language associations for some related documents as well. For state-specific information, you can look to your state education agency, which would be your State Department of Education or State Department of Instruction. Also look to your state professional association. If some states have a separate licensing board, that would be a good resource to consider as well. And the ASHA website and the State Council's website provide direct links to specific resources. For example, if you go to asha.org, click on the Advocacy tab. There you'll be able to locate state-specific information and advocacy initiatives. You can also find advocacy resources located there as well. Here you can access school funding advocacy resources, for example, and look at their page that's provided by the ASHA School Finance Committee. Some of the key issues in states are related to school finance or school funding issues. More broadly, the ASHA website also provides other advocacy resources. For more information regarding the State Education Agency's Communication Disabilities Council, or to connect with somebody in your state, please go to our website and look under Contacts. Thank you for listening to this overview of regulations versus best practices, what professionals need to know, and this presentation is designed for school-based, district-based, and state-based speech-language pathologists and related professionals. We hope that this has been a helpful overview of where there can be conflicts between best practice and regulation.